Hello friends, today in this session we are going to discuss the case of State of West Bengal versus Administrator Howrah Municipal Corporation and others. First, let us briefly understand this case. In this case, the West Bengal government acquired 41 bighas of land in the Salkia area of Howrah and handed it over to the municipal corporation for the purpose of establishing a public market. When the market was not established within the stipulated time in 1952, 21 bighas of land were leased out, which was subleased in 1954. The government annulled the municipal corporation's resolution and ordered the land to be reclaimed. In 1959, the lessee filed a suit to validate the lease, while the municipal corporation filed a suit to recover possession. The district court held the government liable to pay compensation but declared the benefits given to the encroachers as illegal. The High Court dismissed the petition filed under Article 227 of the Constitution, stating that the appeal was filed 1 year and 9 months late. The Supreme Court held that the term sufficient cause should be interpreted in a way that promotes justice. Considering the appellant's active efforts, the court pardoned the delay in filing the appeal and set aside the High Court's order. Under Section 5 of the Limitation Act, the delay in filing an appeal is acceptable only if there is a valid and genuine reason behind it. Negligence or inaction cannot be considered sufficient cause, and even the government must adhere to the legal time limits. Now let us study this case in detail. Answer: Appellant West Bengal State versus Respondent Administrator Howrah Municipal Corporation and other. Reference AIR 1972 SC 749. Subject: the interpretation of sufficient cause under Section 5 of the Limitation Act 1963 cannot be broadly constructed merely because the party is the government. It should be understood in a manner that facilitates the improper advancement of the judicial process. Facts of the case: approximately 41 bighas of land in the Salkia area of Howrah were acquired by the West Bengal government for the purpose of establishing a market. After acquisition, the entire land was handed over to the first respondent, the municipal corporation, with the condition that it would be used exclusively for setting up a public market and no other purpose could be pursued without the government's prior consent. However, the public market was not set up within the stipulated time. As a result, in 1952, the first respondent passes a resolution to lease about 21 bighas and 9 katha of the land to the second respondent. On February 12, 1953, the appellant was informed of this decision, and on March 27, 1953, the first respondent executed the lease deed in favor of the second respondent. Subsequently, the second respondent subleased the land to respondents 3 and 4. On April 12, 1954, the appellant issued an order under Section 586(1) of the Bengal Municipal Act 1932 to cancel the resolution of November 28, 1952 and ordered the municipal corporation of evict the second respondent from the land. In response, in 1959, the second respondent filed a title suit number 15, seeking a declaration that the lease in his favor was valid and that the government's order of April 2, 1954 cancelling the municipal corporation's resolution was illegal and void. In response, the first respondent filed title suit number 10 of 1959 against the second respondent to recover possession of the property and profits. In the decision, three references arose under Section 18 of the Land Acquisition Act, which were related to the various cases of 1958 number 21 and 40 and 1959 number 13. Respondents 1 to 4 demanded increased compensation and claimed excessive rights over the land. District Court on June 27, 1963, the Additional District Judge of Howrah delivered a judgment in the three land acquisition references cases, holding the appellant liable to pay approximately 16 lakh rupees as per compensation. It was established that the state had the right to possess the entire land. However, the benefits granted to respondent 1 to 4 were considered illegal and beyond jurisdiction, as they were mere encroachers and had no valid ownership rights or interests in the land. High Court. To challenge the District Court decision, a writ petition was filed under Article 227 of the Constitution on May 17, 1965. After hearing the parties, the High Court passed a general order on August 18, 1966, dismissing the applications filed by the appellant. The court considered the delay in filing the three appeals under Section 5 of the Limitation Act as unacceptable, although the decree capable of appeal was passed on September 21, 1963. The appeals were filed only on July 3, 1965, which was a delay of 1 year and 9 months, and the court deemed the delay unacceptable. Supreme Court. The court held that the term sufficient cause should be interpreted in a manner that promotes justice, provided there is no negligence, inaction, or lack of authenticity on the part of the concerned party. Wrong advice given by the legal professional in special circumstances may be considered sufficient cause under the relevant section. However, this is not a universal principle that automatically exempts parties from the consequence of wrong advice. In the court's view, since March 4, 1965, the appellant had been making continuous and active efforts to challenge the case. The court concluded that considering the circumstances of the case, the appellant had shown sufficient cause. It could not be held responsible for any inaction or negligence that would deprive it of the protection provided under Section 5 of the Limitation Act. Therefore, the court agreed to accept the three applications filed by the appellant in the High Court and so forgive the delay in filing the appeals. As a result, the Supreme Court set aside the High Court's order passed on August 18, 1966 and accepted the appeals. The applications filed by the appellant under Section 5 of the Limitation Act were accepted. Legal principle propounded. In this case, the Supreme Court established the following legal principle. Point A. The interpretation of sufficient cause under Section 5 of the Limitation Act 1963 should be made to promote justice. Point B. The delay in filing an appeal will be accepted only when there is a valid and genuine reason behind it. Point C. If a party shows negligence or inaction, it cannot be considered sufficient cause. Point D. The government, like any other party, is required to adhere to the legal time limits. Point E. If the lower court's order was within jurisdiction, the High Court had no right to interfere with it. Point F. Unwarranted delays in judicial process cannot be accepted unless there is sufficient cause. Please watch full video, share and subscribe to the channel. Thank you.